We are live. And yeah, I wanted to come on and do a read through of this. And I've got my good friend Noah here, who
Was
I'm going to introduce him here completely in a sec to give you a little bit of idea of credentials if you can't see them in the picture behind him. But just wanted to kick this off first, and this is a thing that you've seen a lot of people say, and I just want to reiterate it first before we start on any of this read through here is don't attack WotC employees, don't harass anybody. We've said this a bunch, but
Mhm.
there are a ton of people who they can't talk about it for fear of their job. And I know I've seen it. People are like, oh, if they were really cared about it, they would just speak by quitting their job.
Yeah.
That's a really big statement from people who've never really had to rely on a job to keep them and their families fed and housed. Like, you can't just give up a job. Some people don't have that freedom.
Right.
And a lot of these people, they're with us on this, you know?
I kind of want to reiterate what you're saying. Like,
Yeah.
obviously, the employees at WotC love this game just as much as we do, and
Mm-hmm.
they're being affected just the same that we are. And I do think that it is incredibly important that we send them a lot of love, actually,
Mm-hmm.
because they don't have as much say as you think they do. And
Right.
so, and like for example, there was a lot of vitriol going out earlier today from another YouTuber that I will not name because I don't want to give them any views on their channel.
Mm.
That was made a video directly attacking the head of the assistant influencer manager for Wizards of the Coast, and that
Not
dude's
cool.
just a nice guy.
Mm-hmm.
And so, yeah, if you're out there and you see people going after employees, just spread that love and tell them, hey, don't go after employees. They got nothing to do with this.
Yeah, definitely. So before we dive into the OGL itself, no, why don't you give everybody your credentials so I don't just say I'm talking to a guy who's a lawyer, and then it's just my word versus your
Yeah.
minutes. Yeah.
So hi guys, I'm Noah Downs. I'm a lawyer, but I like to say I'm a cool lawyer. I am a gamer and I actually work in the gaming industry full time. That's what I do. I represent publishers, creators, both in digital and tabletop gaming. I'm a Twitch partner myself, although I don't know if I should say that on a YouTube stream.
That's fine.
Uh,
This isn't
and
TikTok. They don't care.
Yeah, exactly. And so I've been following along with this closely. I represent a lot of industry folks and a lot of third party creators in the space. I'm very passionate about this. But yes, I am a lawyer. A piece of paper here that says that, and another piece of paper here that says that I'm a lawyer, and then this piece of paper says that I know intellectual property law. Quick disclaimer though, everything I'm going to talk about today is for informational purposes only. I am a lawyer. I'm not yet your lawyer unless I literally am your lawyer, in which case, hi, welcome to the stream. And so I'm going to be talking about specific circumstances, but your specific circumstances may always be different. You should consult a lawyer. I'm available for hire, but I'm not, going to give you specific legal advice. This is not creating an attorney-client relationship. What I'm trying to say is take this legal advice and don't try it at home. Go to a friend's house.
Yeah. So first, we'll start with, before we dive into the OGL itself, I just wanted to talk about the statement that was released alongside it. Because there is some stuff that's said in that statement that's different, or at least not addressed in the actual OGL itself. So once again, we have Kyle Brink here, a name behind the statement, saying, what this is all about. Right, we're giving the core DNA mechanics to the community through Creative Commons license, which we'll get into what that is, and that it's going to basically be OGL 1.2. We heard 1.1 was leaked, and there was going to be a 2.0, and we've landed on a 1.2, which I don't know. Semantics of the numerical system may not be important, but either way.
I think we're building towards a 2.0, and like 1.2 is like the draft version or whatever they're trying to claim it is this time.
Yeah. So they go on to say, what's not in here? There's no royalty payment, no financial reporting, no license back, no registration, no distinction between commercial and non-commercial, right? And again, we don't have to belabor the leaked 1.1, but all of those things were in that, right?
Right.
It does. It says nothing will impact what you already have under 1.0A. That will always be licensed under 1.0a. Your stuff is your stuff. That's a good thing. We can confirm that. That was never really, I didn't think, in question anyway, but that's just a confirmation that what you already put out, they're not going to go back and start coming after you for things that have been out for potentially 20 years at this point, right? So one thing they did state in the statement there is no royalty payment. Now I don't believe that's actually in the 1.2, but it's said in the statement. So it's a draft, which is very clearly plastered across all of it, which we have that for the first point.
They literally use like the generic word watermark.
Yes. So it goes on to say protecting inclusive play experience. Let's see. It says the content clearly associated with D&D classes, spells, and monsters is what falls under the OGL. You'll see that 1.2 lets us act when offensive or hurtful content. We'll talk about that because there's specifics that are interesting with that piece. Virtual tabletops. It doesn't have a policy. I feel like it has more of an FAQ than a policy.
Yeah, it actually creates more questions than I think it answers, which is kind of funny. It's not like a guideline. You're exactly right. It's like an FAQ, but like a limited FAQ.
And then it does flat out in the statement come out about deauthorizing the OGL 1.0a. And it says that basically they are going to do that, which is the biggest push that the community has been making since the start of this, is leave OGL 1.0a alone. I always felt that they were going to come. Well, actually, I never thought that they were going to come for this. And then ever since this has started to happen, it seems more and more apparent that that's been the goal all along, is to force you into whatever new version they come up with so that you have to work towards whatever the new edition is. So you can't continue to create for 5e. Or I guess 3 and 3.5, which I guess you'd also be kicked out of as well, from 20 years ago. And then very limiting license changes allows us only 2 sections can be changed of OGL 1.2 when it's live: how you cite wizards in your work and how we can contact each other. We don't know what the future holds or what technologies we'll use to communicate with each other. So their thought process, and again, it explains it further in the document, is in theory, everything else should be static, except for these 2 sections will shift based on what they say. And then it says, what are the supporting documents? There'll be the virtual tabletop policy. They'll have, it says ownership disputes. You own your content. You don't give wizards any license. No hateful content or conduct. Again, we'll get into that. And then this creator product badge. And they also go on to say, which I did think was good. It says, after you've read the new 5.1 SRD, you'll be able to provide your feedback on the review documents in our survey, which will be live tomorrow. The survey will remain open until the 3rd of February. We'll talk on or before February 17th, where we'll share what we heard from you and the updates to the OGL document as a result, which I think is very clearly explaining that they are going to be very public about what the feedback says, which, whether or not that's been the case or however it's been handled, they are committing to showing us that what's going to happen. At least that's how it reads anyway, which is good, because that's one of the things. If you have all this feedback and it's all contained in your silo and you control the messaging, we don't know what's actually being said. And it's going to take as long as it needs to.
Yeah.
Which is fine. I mean, I guess that's good. You're committing to not just be like, hey, we got to have it out by March 1st. It's this, you got to sign it by next week or you don't get to make content anymore. So
just make sure you get it done by like February 17th though.
Yeah, right. Exactly. All right. So let's dive in. Now, you actually, by the way, I also want to point everybody out to a post. I retweeted it earlier today that you put out that kind of went through, talked about what we want as a community from this update and what we had said we wanted when 1.1 was leaked versus what 1.2 actually says.
Yeah. Do you mind if I do a quick shout out where they can find that too?
Yes, by all means.
You can find it on my Twitter at MyLawyerFriend. MyLawyerFriend is my handle across everything. So, but that is where I posted that article, and that's where we will probably be posting updates here. My law firm and I are kind of going through like the more subtle things here still. Because like I said, this is what my law firm does. So, Yeah, let's dive in.
All right, so I'm going to go ahead and pull it up. So on screen, we're going to disappear, but you're going to see the actual OGL itself.
They'll probably be grateful for that.
So it says the core D&D mechanics, and they list a bunch of pages for the existing 5.1 SRD, are licensed to you under Creative Commons Attribution 4.0 International. That means that Wizards is not placing any limitations at all on how you use that content.
Right.
Now, can you explain? I've heard that there are multiple Creative Commons. What does that mean? 4.0 International.
Yeah, so the Creative Commons 4.0, it's the Creative Commons Attribution 4.0 at
Mm-hmm.
International. So there's a lot of different Creative Commons licenses. They update them all the time. And so what this is it's an international license that requires attribution if you use the work. And they have specifics for how you do attribution there. You can go into a super deep dive on it, but that's at its core, it's an open license, meaning that basically the core mechanics they're trying to say are now Creative Commons. They're open for anybody to use, completely free of interference from D&D. That they're not even technically subject to a morality clause. I think I got to double check that. As long as you attribute where they come from, and it's an international license as well. What's interesting is that this is kind of a nothing burger, if I'm being honest,
Mm-hmm.
because game mechanics are not copyrightable.
Right, and this is a thing. So I just want to point this out because a lot of people have said this for a long time, and it's true. But I've also seen things that people have said. They're like, "Oh, you don't need to worry about it because you can never copyright game mechanics," and that's always been true. But the people still want to use the existing open license because of the SRD content, and it kind of we'll get into it, I think, a little bit more in here about what you're allowed to reference,
Yeah.
and then rather than having to, like, if you wanted to include something in your document so people don't have to go look somewhere else. So yeah, but basically what they're saying is the stuff that we can't copyright anyway, we're we're putting in Creative Commons so that you can have it, but you always had access to it.
Exactly. And what's really interesting about that is that it's good to have a license to that, even rather than just rely on pure nuts and bolts copyright law, because then what you can do is you can say, hey, you know what? I know I can look at this piece of paper that's, is the Creative Commons for Attribution 4.0 International. And I can say, this allows me to use this, rather than saying the law says I can, but does Wizards disagree? Because
Mm,
the last thing you want is some sort of DMCA or lawsuit. And that's one of the nuances I think that other major legal minds on YouTube maybe have missed,
hmm.
is that the OGL provides comfort and
Yeah.
security. So even though you can say, do we even need it? And that's a nice hot take headline, you do. So this is helpful for creators.
And I think, and then again, you guys will have to do your own research, but just a quick rundown of things that I believe that are covered in those pages are basic rule mechanics, leveling up, multi-classing, hit dice, proficiency bonus, alignment, ability checks, saving throws, resting, downtime, combat, the concept of spellcasting, general rules for monsters, the conditions, the concept of backgrounds, the equipment and the tools, and I think the concept of feats, I believe, is everything that is pretty much covered under that. Like, those are Creative Commons. But that also means that the concept of, like, things like, well, we're calling them species, classes, specific spells themselves, magic items, specific
Yeah.
monsters, all of that is not. So, in theory, if you are making content that doesn't include that or is all original, then you're safe to produce that. You could produce that under the 1.2 OGL and would not, or without, I'm sorry, without using the 1.2 OGL. So if you were going to create your own original class and not use any other like spells or things like that, then you'd be okay. Is from what
Yeah,
I
as
can
long as
tell.
you're sticking purely to game mechanics,
Yeah.
then that'll work. And that's difficult. That's part of the reason why a lot of clients ask me, well, why do I need this if game mechanics are not copyrightable? And that's because D&D has been so intertwined with its shell on top of that it's just kind of difficult to separate the two. So this is good.
Yeah, because like I said, I mean, Imagine you're creating your own level 1 to 20 spellcasting class, but you can't reference or use any of the spells that exist in 5e.
Yeah.
Good luck, is what
Yeah,
I have to
exactly.
say to you on that, because that's going to suck. Maybe if you're making a martial class, you'll be fine. All right, so we go on. It references the virtual tabletop policy, which isn't really a policy. If you click that link, it actually takes you nowhere. But there is something at the end of this document. Now, they bring up these creator badges. And it says you may use any of the following badges, which are just 3 different color versions of it, in the creator product style. So as long as you comply with the guide, and I guess the concept of these badges are that instead of referencing and putting the OGL in your book or your product, you could just plop this creator badge on the front cover or of your product, and then that like absolves you from saying like or saying that I'm in agreement with whatever's going on here.
Yeah, it's flair.
Okay.
It's advertising. Like so it's promoting D&D.
And then we have the very big thing right at the bottom, notice of deauthorization. Again, saying that 1.0 is no longer authorized. This means that you may not use that version of the OGL or any prior version to publish SRD content. Effective date, which is not listed because it is very clearly with the watermark a draft.
Oh, this is a draft?
Yeah, so I've heard. But again, I still am curious about the folks who may have signed those sweetheart deals in December. What happens to them?
Yikes.
Because like your version of the OGL, I guess in theory no longer exists, but you already signed that contract.
Yeah, which means that it does exist for them, so they'll probably waive it, but like they definitely are in a pickle.
Yeah, like I said, I mean, not that I'm, but it may be telling if some folks are getting promotion on official channels, as that was part of the sweetheart deal. You may know who
Right,
signed
exactly.
it. Okay, any previously published content remains licensed. Then we get into the actual body of it itself. It explains, this whole us, we are covers wizards, you and your is us, the creators here.
What I'll be honest, this was when I realized that this was going to be a better document overall. This license made great strides. It clearly Wizards listened to the community, whether it was because of the wallet attack or not. But this is when I realized this is going to be a much better license because it's not poorly written. OGL 1.1 draft was so poorly drafted that it was hard to read.
Mm-hmm.
This is a contract. It's nice.
Yeah. So it goes on to cover what content is covered. It talks about the works covered, again, references the virtual tabletop policy. And then, your licensed work must be covered under this section, contains our licensed content. Okay, so copyrights. We are only licensing you our copyrights in our licensed content, except under section 5.a, which we'll talk about.
Right.
And then license in consideration for your compliance with this license, you may copy, use, modify, and distribute our licensed content. I feel like this is all pretty standard stuff, or am I off on that?
Section 1B is really important.
Okay.
Where it says works covered. Important distinction because a lot of people were confused about, hey, does this apply to the fan content policy or something like that? This says that the license only applies to printed media and static electronic files such as EPUBs or PDFs. So basically, your items, your compendiums, your adventures, that kind of stuff, but it does not apply to your podcasts, your let's plays, all that kind of stuff.
Right, and it also, again, previously we had things that virtual tabletops wouldn't be covered, but now they're saying that there's a separate policy so that they're not affected by OGL 1.2.
Precisely.
All right, so I think we can kind of move into section 3, I believe, which is what you own. Or is there anything
you want to go to section 2, actually?
Okay, go ahead. Let's talk about section 2.
Yeah, so section 2 is the license.
Okay.
This is the most important part of this entire agreement, and what it does is it gives 3 primary things. So kind of going through it, in consideration for your compliance with this license, basically saying if you agree to this license and continue to comply with it, you can copy, use, modify, and distribute the content that we license to you. It's basically SRD 5.1. Around the world. It's a worldwide license, which is dope. They're saying that the license is perpetual, which is what OGL 1.0a was. It's non-exclusive, meaning that it's not just like it's not personal to you. It's anyone can sign it.
Mhm.
And finally, they're saying it is irrevocable. However, they changed the meaning of irrevocable, which
How is that possible?
so because they redefine it. So here's the thing. A legal term can be redefined in a specific contract if both parties agree to it. Meaning that if you and I agree that irrevocable means something different than what it normally means, and it's written down in the contract, that's fine. If you look at the starting the OGL playtest blog post that they put out 7 hours ago now, it's literally says, third, this license specifically includes the word irrevocable. What it does not say is that this license is irrevocable because it's not.
I see.
So what irrevocable would normally mean is that this license cannot be revoked.
Right, which is what everybody wants.
Yeah, meaning that if you agree to this license, this is your license until the end of time. What they've said here now is that it's irrevocable with regard to specific content. So if you draft and publish an adventure under 1.2 tomorrow, and 1.2 is revoked on Saturday, then that adventure you released under 1.2 is safe, but you can't use 1.2 again because it's been revoked.
Wow.
It's so stupid.
Yeah, that's I mean, that's the kind of stuff that any of us would be like, cool, they put the word in, we're good.
Yeah, it's like, oh, the word irrevocable's in there. I'm sitting here like, no, that's not what irrevocable means. And it's really telling that they didn't say that the license specifically is irrevocable. They said the license specifically includes the word irrevocable. And honestly, it's so funny. I'm literally chuckling. Sorry.
No. That's good to know. So now, okay, so that's the big one. It also cannot be modified except, so this is the other part that they had mentioned. The only sections that can be modified after the license is finalized is Section 5 and Section 9A.
Now, let me tell you, typically as I'm going through a contract, the minute I see a reference like that, the next thing I do, instead of going to Section 3, is I usually go to Section 5 and Section 9A to see what they are.
Let's do that then. Let's go to 5.
So that you control your content, and then I would say, okay, sounds good, we'll get there. And then 9A is notices, which is fine.
Okay.
So popping back up, so that's not crazy. What we need to mark then is that we need to take a closer look at Section 5, because that's one that they can change part of, specifically the attribution provisions. So once we get to Section 5, we'll dive into that.
Okay.
Cool.
So what you own in Section 3, your license works are yours. That's good. This is basically, from me reading through it, you own what you create. But there's a caveat that we'll get to. This is basically the antithesis of the license back provision that we had in the original 1.1, which is we own it, or you put it out there, but we can do whatever we want with it.
Right, exactly. This is, you own your stuff. This is fantastic. This first part of this is fantastic. It is honestly one of the biggest concerns that I had with the 1.1 the section. Now, however, what they're saying is, however, you acknowledge that we might come up, with something similar to what you're making. And if you think that we have made something that is a little too similar, wink, wink, nudge, nudge, or that one of our licensees, might have accidentally stolen your content, wink, wink, nudge, nudge, then you cannot force us to take it down. You can only sue us for money.
Yeah. So let's give it. So I come up with a brand new spell, let's say.
Yeah. Let's call it the full nerd immersion.
Right. Sure. We come up with that. I put it out. And it's very specific, and it's, as far as we know at the time, completely unique to what I created.
Yeah.
And then a year from now, Wizards of the Coast puts out something that is remarkably similar to what I put out. I can't say, hey, I did that first. Here it is. You can see all the publication. Take that down. And they can say, No, we're not doing that.
Right. They can look at you and say, no, we're not taking it down. And you could potentially sue them for copyright infringement if you can prove that they had access and that there was enough similarity between the two and the other elements of copyright infringement. And if you win, all you can get is money.
Yeah, you must show that we knowingly and intentionally copied your licensed work. Access and substantial similarity will not be enough to prove a breach of this section.
Yeah.
Yeah, I'm assuming there's a lot of leeway legally for substantial similarity.
Oh yeah, well, I mean, it's got a very specific meaning under copyright law, but you know, at the point where you're asking a judge to do it, you've already paid $100,000 to a lawyer to get you and Watsy into that part of court, and at that point, you're not going to win. So this is basically there, unless you're the biggest fish in the pond, we're not talking to you, clause.
Gotcha. All right. So you have your content, but they might be able to mimic it, and there's really not much you can do.
I will say that as a lawyer, I would have drafted the same thing.
Okay.
This is not inherently evil or bad because Watsy is a mega corporation. They are going to inevitably, if you have 10,000 crabs typing on typewriters, then eventually they'll reproduce the works of Shakespeare. There's a 1 in a trillion chance that they're going to do. Let's just do a quick shout out that they're going to recreate the Hand of the Eight Adventure from D and Dave or something like that.
Sure. Yeah.
This gives you an avenue for relief, but it is still kind of slimy to say we were not going to take it down and to limit your remedies. I think that does suck.
Yeah.
Yeah.
All right. Section 4 is what we own, which is just a one-line thing.
Yeah, that's very straightforward.
All right. Now we're on to Section 5, one of the sections they can change.
Right. And they can change the attribution sections of Section 5. So Section 5 is basically you control your content. You can make it available under any terms you choose. However, you cannot change the terms under which we make our licensed content available. So you cannot suddenly make your content available. You can charge for your content, but you cannot change the terms of this license, and you cannot change the terms of the Creative Commons license governing the mechanics. So that's kind of what that means in that first line.
Okay.
However, the attribution is in 5A. You've got to indicate the work contains licensed content by including the full text of this license or applying the creator products badge.
Okay, that seems to me, at least on the face value, that would be the easier way to go.
Yeah, creator products badge, gives D&D marketing and branding. And so it's a win-win for them. Or you can put the full text of the license in your license work as you were required to do with OGL 1.0A. And then 5B is just a license control section. It's kind of a nothing burger here. So 5A is just kind of reiterating, hey, in addition to the option you had under 1.0A, you also have another option, which is just to put the badge.
So if I'm understanding that correctly, this is not like the contract that you had, the truly unopened open game license of 1.1, where I had to sign a thing committing to this. This is how I confirm that I'm agreeing with this license. Is that correct?
That is correct. So what this basically means is this is just how you do an attribution. So this is saying, hey, I use this license and this governs how you tell people that you used it. Now, what's interesting here, and this is kind of a sneaky thing, but I'm not going to really fault them for it, is in Section 5A, where it says, or by applying the creator products badge in compliance with the then current style guidelines, that section. Yeah, right there. Changing the then current style guidelines gives them a lot of leeway if they want to be really shitty about it. They could say this is a product produced and owned by Wizards, even if it's not. And then, I mean, that would never work. They would never do that, to be honest. Like, I don't even think in a million dreams they would. But it is technically a loophole. So I just want to make sure I identify it before like the lawyers on Twitter got after me about saying this is enough for.
Sure. All right, then I think we move into Section 6, which definitely has some interesting stuff in it too. So this is basically what you're saying. You're agreeing to the following things, as far as I can tell.
Yeah.
that you're of an age that it's cool to do this, or you have a parent or guardian, which I think is pretty standard stuff.
That is very standard stuff. And let's see. I'll be honest, I got really happy when I saw this section.
Now,
Because
why? Yeah.
it is normal.
Okay. All right. That's good, I guess, right? We
It
like
is-
normal.
It is very normal. It gave me a sense of normalcy, which is great. 6A, obviously, this is a game, and so they want to make sure that you have you are of the age to do this. You're not going to be a 13-year-old that's just publishing, as long as 13 is below the age of majority. That's very standard.
Okay.
Part of the reason that's important is if you are younger than the age of majority in certain countries, then you can disclaim your contracts as soon as you turn the age of majority. So like there's a fun part of US contract law where like in certain places, if you're younger than 18 and you sign a contract, once you turn 18, you can disclaim that contract, which is nice.
Oh.
Yeah. Authority, you have the power and authority to enter this license. Very standard. 6C is normal. It's incredibly important to have it in there. Basically, it's saying, hey, you're not going to rip off somebody else and then and put it in your work, that kind of thing. However, what it does not include here is it doesn't give you any leeway. It says your work does not and will not rip off anybody else or infringe anybody else if you read the specific language. What it should read is your work does not and will not knowingly or intentionally infringe on somebody.
Oh, that's important documentation there for sure. Language.
Remember when I was talking about like 1,000 crabs recreating words of Shakespeare? Same thing here. So
Gotcha.
yeah. 6D, no endorsement. That's absolutely fine. That's a nothing burger standard. 6E and 6F kind of suck. The way that they're written.
Yeah, 6F specifically, in my opinion.
These are normal. Again, I would expect to see them in here. I've drafted them myself. And 6E is basically says you're not going to violate the law. What it should say is you will not violate the applicable law.
Okay.
Because if you live in Alaska, there's no way you know what the laws are in Ecuador. So you could actually break the law.
Yeah.
So 6F, no hateful conduct or content.
That's good. We think we can all agree that the intention of this is good. I think also the 1.0 had this anyway.
It's similar. It's a morality clause. I remember seeing it in like Chaosium's license. And so I forget if it's exactly in the 1.0A. But the problem is at the end where it starts, we have the sole right. You see that?
Yeah.
Wizards is the arbiter of everything here. They can say that, hey, your hateful conduct, Nerd Immersion, is that you made this video and screw you. You can't contest that in court.
Yeah. So, I mean, it's the problem, and it's also, again, like a lot of people are saying, it's not just applicable to the content you produce. It's, you will not include in your licensed work harmful, discriminatory, legal, obscene, or harassing, but then also or engage in conduct, which is just really in your everyday life, which could, like, we've talked, there's been conversations, people said, it's like, so what if I go to a football game, right?
Yeah.
And I'm like, in jest, but like I'm shitting on the other team because it's a football game and there's a rivalry. Is that harassment?
Exactly.
But it's not my call to say if it is.
Right. Exactly.
Is that harmful? Potentially, depending on who's reading it and seeing the situation. Again, I've talked about this, and there are a lot of folks that may or may not have. They might do photo shoots. They might be influencers. They may be OnlyFans creators, cosplayers, right? They may take, again, say you're an OnlyFans creator who's also like a stellar publisher of D&D content, right? And even if it's not like even if it's just like lewd photos, right? Nothing crazy. Is that considered obscene? Yeah, it very well could be considered obscene, which means that you, purely because of another stream of income that you have and something you do completely unrelated ultimately from what you do in terms of creating stuff for this tabletop scene, you are now potentially able to just have your license revoked because you choose to do that.
Because of the nature of the industry we're in, you know, where we have influencers and content creators and all that stuff, and YouTubers and Twitch partners, like I represent adult film creators and
Sure.
like that love D&D, and some of whom write adventures for D&D in their spare time, and like theoretically Wizards could be the morality police on this. I do want to kind of throw out just some funny thing from chat real quick that I just noticed.
Sure.
Somebody gave you $5 and it said no morality clauses ever, and their name is Bangs Naughty Bits, and I just think that's just hilarious. So
yeah,
I had to point that out.
Sure.
But yeah, so that part sucks. 6F has to change.
Yeah, and I think I'll pull a line from our good buddy Lynn Kodega if I can.
Absolutely.
That says, in the wake of Spelljammer's inclusion and public treatment of the Hadazee, it remains to be seen if D&D is even capable of moderating this kind of content in a way that will be respectful, inclusive, and progressive.
Whew.
You know, which is also nothing. I mean, they're not wrong, right? Like, who are you to make this call? And it's, again, I think I saw somebody on Twitter say, what if in 2 years' time, WotC decides that my face is obscene and they don't like the way I look? So they're like, well, that's obscene. Strike down, you know?
Yeah, exactly. I mean, I think overall morality clauses in this, I understand if an individual publisher of an SRD like it wants to include it, but I don't think including it in the base license is something you should do.
I mean, I think this is very clearly, it's a safety thing for sure. It's also designed to target another 3-letter acronym company that did some pretty awful things recently.
We won't talk about them.
No, but and I feel like it's definitely to make a stance against that. However, it has larger implications beyond that.
Yeah, exactly.
All right, so that gets us into section 7, modification or termination, which I think is relatively standard stuff, I believe, right?
Yeah, so I mean, let's hit it real quick. Modification, we can only modify the provisions, you know, as they said before. Honestly, it's very interesting that they put this in there twice. It's the only place where they really repeated themselves. You know what I mean? And then 5B termination, they can terminate the license if you infringe on their IP, which is normal. What I am not keen on, here's what I don't like. They say they can terminate the license if you bring an action challenging ownership of their licensed content, trademarks, or patents. Or, you know, that, I'll be honest, fairly normal, kind of to be expected. I don't like that they expressly put it out there because it feels like a warning, but I'm not gonna get too chuffed over it. You know what I mean?
And then go on to say, or violate 6F, which is what we were just talking about.
Literally 6F, like, and that's where we get into that, is that just gives them all the more power there. And then, however, I do like that in 7B2, you have a 30-day cure period. So in the event that if you breach any other term here, like if you forget to add attribution or something like that, then you can have 30 days to fix it. It's not going to be just an automatic bam, you're out.
Which is, I mean, I don't know if that existed in the 1.0A or not, but either way, I feel like that's a reasonable amount of time. If you forgot to put the creator badge or you uploaded the wrong cover or what have you, it gives you time to fix it.
Precisely. And/or it gives you time to issue stickers or reprints if it's a print production.
Correct. Yeah. So section 8 looks pretty standard too.
8 is very standard.
Okay, and this is just kind of saying, they're just disclaiming pretty much most of the stuff we already talked about.
For those of you who aren't familiar with contracts, the reason that's in all caps is not because Wizards is shouting at you. It's because years ago, very white men with very white wigs decided that you needed to offset super important information and waivers of rights in all caps. And because it's theoretically the most important part of the contract or something like that. But in doing so, they failed to realize that every part of a contract's important. And so it just sounds like they're shouting at us, but they're not shouting at you.
All right. Then we move into section 9, which 9A is the one that they said they could change.
It's basically, how do we contact each other?
It says either email or physical address, and they give you an email, OGL notices at wizards.com.
Yeah.
And it seems like the provision for this was like they said, if everybody in the whole world gets a digital implant that allows us to talk via that, and that's how we communicate in 20 years from now, they can adjust it to say that we'll communicate via that.
Yeah. 9B is incredibly important because 9B is how I know that Wizards of the Coast read my article.
Okay, that's good. That's good. For those who didn't, what does that mean?
Yeah, so 9B talks about the entire agreement and disclaimer of reliance. So the entire agreement means that if it's not in the four corners of this agreement, it doesn't exist. So if Wizards has told you something that is inconsistent with this agreement, then it doesn't exist. So if they say, hey, you can sign this, but in reality, like we're gonna actually pay you to do this, and then you agree to this, doesn't matter. Disclaimer of reliance is basically that you're not going to rely on their advice or anything they put out. And that you have not relied on anything that is not expressly part of this license. So they're not saying that this license is going to be around forever.
Mm-hmm.
And so if they at some point revoke it, because they can, don't forget.
Yes, correct.
You cannot say you relied on it being there.
So that's that. Okay. That's clever.
Yeah. 9C, very standard. 9D, I'm seeing a lot of chatter on Twitter about severability.
I'm some in the
That's normal.
here in the chat here says they can change 9A to be unenforceable and then make the license void with 9D.
So 9D basically says if you cause something to make the entire license void under law, then you're going to have a lawsuit. And it's gonna, that's gonna be a problem. I'm not too terribly worried about that. It's certainly a concern, but it is not an overt concern that I have here. Because right now Wizards is kind of scrambling, and I think that this is more protection for them rather than going against you there.
Okay. Yeah, I definitely saw a bunch of people freaking out about this one on Twitter and in various Discord groups saying like it seems like they can just do whatever they want.
Yeah. Now the second part of that is very standard, where it basically says, hey, if any part of this license is unenforceable, then it doesn't affect the rest of the license. That part's just getting carved out.
Okay. This is one that a lot of people have also been talking about is 9E.
Yeah. Got to sue them in Washington. And also you have no class action, collective, or joint action. And also I think you waive the rights to the jury. Is that right? Yeah.
Yeah, you waive the rights to any kind of, it's going to be handled basically, it sounds like outside of court almost.
98% of lawsuits are settled outside of court anyways.
A license will be resolved solely and exclusively through individual litigation in the state or federal courts located in the county in which originates successor's headquarters. Each party hereto irrevocably waives the right to participate in any class, collective, or other joint action with respect to a dispute.
Yeah. And so it's going to be resolved out of court anyways if you sue them. And we would only go that far forward in the event that there isn't, in the event that we had an amazing case, we wanted to get precedent. And even then, you're not waiving your right to sue. Except under that one section. So this is very standard. I'll be honest. I think that 9E is the primary reason that they wanted to update this agreement.
Okay.
Because under 1.0A, I could go sue them in my backyard.
I see. And this is also potential. Some people in the chat were saying, like, what if you live in another country?
Yeah.
Well, I guess you got to fly over here.
9F headings and footnotes. It just basically says, hey, it's for reference only. Don't read into the headings. 9G is that waiver of jury trial that we were talking about, and 9H is my favorite part of this license. Review by counsel. You should hire an attorney to help you with this.
And that's a pretty standard thing too, right?
Absolutely. And my lawyer friend is available.
Yeah, so I guess I did see a lot of people saying like you can't. There's contracts or policies in place in the U.S. that says you're not allowed to like you can't waive your right to trial by jury, but like the
That's not
Constitution and stuff.
necessarily
But I was gonna
true.
say if it's in a specific agreement that you agree to, doesn't that like I mean I don't know if specific beats general in terms of contract law, but that's kind of how I saw it.
Yeah, yeah, if you agree to this jurisdiction and agree to this venue and agree to waive your right to a trial by jury, then 9 times out of 10 that's going to hold up.
Okay. And then
Plus, I'll be
lastly,
honest, you don't want a trial by jury.
yeah.
In my experience, trial by jury is the most nerve-wracking trials that I've ever had in my career.
Hmm.
I've had over 400 trials in my career, and trial by jury, when you have 12 people in a box, they can do anything.
Sure.
Judge at least knows the law.
Yeah.
So
And then the last page of this is this virtual tabletop. I'm going to put air quotes around policy,
yeah, loosest
version
terms.
1.0. And it says, why does it need a virtual tabletop policy? And I think we can both agree that this is the option was to have nothing or force fit everything into the 1.2. So having a separate policy seems to make sense.
Yeah, absolutely.
So it says we support virtual tabletops, which is a nice sentiment. Which again makes me the way it's written makes me feel like it's like a loose FAQ, not a policy. But all right.
Mm-hmm.
Um, as they advance, their functionality will raise tricky questions. What's the line between a virtual tabletop and a video game? Some of the stuff in here makes me just laugh.
Are
When
they
does
going to
a,
cut into our video game profits?
yeah, right. Well, when does a virtual tabletop become just a replacement for a traditional tabletop? And they basically said if it does things that that replicates you sitting around a table, then it's cool. But if it doesn't, then it's not.
I'll be honest, my personal opinion.
Mm-hmm.
Um, I think they're just incredibly intimidated by how good alchemy is.
Ooh, okay.
Um, and shout out, I love alchemy. They're
Yeah. Me
fantastic.
too.
But alchemy is an immersive tabletop experience. Like they invest in animations, they invest in overlays, they invest in stream friendly assets. And without revealing too much, I know that they're in the works for stuff that will be just is like a direct target of this license. I honestly I think that this will affect Foundry, this will affect Roll20, that kind of stuff.
Mm-hmm.
But I swear, they could have just written alchemy, by the way, yes, we mean you, and it wouldn't have been more clear. So
Yeah, there definitely. I think there's a couple other ones that I saw went to Kickstarter in the past couple of years. I think some I even promoted on the channel had spell effects
yeah,
as part of the thing, right? So it says automatically doing the damage to replicate manual rolling and calculating is fine. It can apply the damage automatically to target's hit points. That's fine. Um, oh yeah, so displaying static SRD con is fine because it's just like looking at a source book.
right.
What isn't permitted are features that don't replicate your dining room table storytelling. That is probably my favorite line because boy, is that just like who wrote this?
Well, and my favorite part is the next line. If you replace your imagination with an animation of the magic missile streaking across the board to strike your target, it's not tabletop experience.
And they throw in the NFT piece here.
Yeah, because they can't justify this. This has nothing to do with a legal need. This is purely them saying, hey, this is the future of our digital revenue, and we don't want you to beat us to market because you have more devs and you've been doing it longer.
Yeah. So, um, yeah. Okay, that's just kind of a wild one. And then they do go on. They do clarify that none of the art from anything that was licensed from the monster manual or anything in the SRD art was never covered. It was just stat blocks and in
Yeah.
names. So you can make your own art of an owl bear and put that as a token. That's fine, but you cannot use the official art, which I think is a good clarification for people who didn't know.
Yeah, this is kind of an interesting thing, and I don't actually touch on this in my blog post. We've never licensed visual depictions of our content under the OGL. You can create a creature called an owlbear with the stat block. You cannot copy our owlbear depictions, but if you've drawn your unique owlbear or someone else did, you can use it. Now, technically, if someone references the picture
Mm-hmm.
and draws their owlbear, they're creating a derivative work,
Yeah.
which is technically infringing if it's not licensed. So I think what they're saying here, and they're giving themselves the leeway to say, you can probably get away with that, but if it's too good, we might take it down. So come up with your own thing.
Yeah. What about OGL 1.0? Yes, you can upload your already licensed content to a VTT. Very clear that it says already licensed, so that doesn't mean stuff going forward, because again, they're revoking the 1.0A going forward. If you own or operate it, you have the same obligations for VTT content that any other website owner or operator has under a DMCA.
Yep.
And then you say this is a conversation. Does that mean the policy can change? Yes, we need your feedback. As the tabletop space evolves, the potential of VTTs is tremendous and exciting, and we don't want to harm their development. And that's their policy as it stands right now. So I saw someone mention in the chat, and I'll ask you, based on what's written here, how easy is it for them to just change this in 6 months, this whole document? Nothing. They can't do that because they can only change those two. Oh, I guess it's a draft. That's the other part, right?
Yeah, it's a draft. I mean, the entire thing can change. I'm hoping it will.
In what? So let me ask you, in your ideal situation, what is the change?
If you give me 3 things to pick.
Okay, yeah, 3 things. Let's do it.
The first 2 are going to be don't revoke OGL 1.0A. And then the third one will be, no, I'm kidding. The first one's always don't revoke OGL 1.0A. They're not going to do that. So what I would say is amend the hateful conduct policy to reduce the broad rights that Wizards has to suppress works that they call hateful.
Okay.
And then the third thing that I would do is make sure that this license is expressly royalty free and also expressly irrevocable.
In the traditional sense of irrevocable.
Yeah, like the actual meaning of irrevocable. Don't get me wrong, this is a huge step forward. Clearly we forced some changes here. There's a lot of work to do.
Yeah. I'm trying to think if there's, yeah, like you said, they're gonna revoke it. That's always what this has been about. I don't think we're gonna get to keep it.
What I mean, and I summarized a little bit about this a little bit more eloquently in my blog post about it, but that would be the primary changes. Everything else is pretty much what we wanted, which is huge. That's awesome.
Yeah, I mean, would you say that we won and so did they?
You funny.
I try.
You're gonna get a lot of people on Twitter talking about, how like, yeah, they won, but honestly, I think we won. They did win, and so did we. Yeah, but it is rough out here. I think that feedback opens tomorrow, right?
Yeah. Yeah, that's what they said. Will publishers still be allowed to make 5e or new content, 5.5e content under the OGL after 1D&D/6th edition comes out, or are they closing that door?
Where is that? Sorry.
That someone just said that in chat here. Cascadian one here. Will publishers still be allowed to make 5e or new 5.5e content under the new OGL after 1D&D/6th edition comes out, or are they closing that door? So if 1.2, so say everything went through as it is, can you still create content for 5e, or would you be stuck to, I guess it depends, because we still don't know what the final version of this is going to be.
Yeah, we don't know what the final version of this is going to be, and I wouldn't put it past them to change the SRD. I mean, them being able to change the SRD is a double-edged sword, because it allows them to add things, but also allows them to take away things. So I think that as they try to move forward, they're going to try and move us off 5e. But I saw somebody in chat also say, hey, put past SRDs in here too. I think that's really important. And so I think that having some sort of archive and making sure that past SRDs are good to go still is important too. So I think that even if we do move to 60 or one D&D or, D&D gibberish or whatever,
Hmm.
then we should make sure that we have back license on SRDs.
Yeah, to cover whatever was done in the past. Yeah.
Yeah.
I did see somebody said, what is it going to take to get them to realize they cannot deauthorize OGL 1.A? The original authors state that this is not allowed under the OGL 1.0. I think this is all of Ryan Dancy's comments
Yeah, Ryan
regarding this.
Dancy
What do
and
you think
and
about
and
that?
Brian Lewis and all the attorneys, and they're incredible. They're fantastic. The laws changed dramatically in 22 years.
Mm-hmm.
Um Here's the thing. It's revocable. OGL 1.0A is revocable because it doesn't say it's not.
Mm-hmm.
Now, that doesn't mean that it's okay for them to revoke it. Under basic contract law, it's revocable.
Mm-hmm.
However, there's a lot of what we call equitable relief that people who are affected by that revocation can take into account. So they can say we detrimentally relied on that license for 22 years and built a business on it just for you to like rip it out from under us. There's a lot of ways that you can go about it. So on its face, it's revocable. That doesn't mean it's okay, and that doesn't mean that a court would say that revocation was authorized to steal their term, and that would likely pay out damages.
Yeah, because I think I saw Paizo said they're willing to go to court over it in
And
their.
yeah, here's the thing. I don't think Paizo should go to court over it. I think Paizo should fund somebody to go to court over it. Paizo, like when I'm gonna Lord of the Rings for a second.
Yeah, do it.
When Aragorn goes over in the movie and with the warg into the river, and
Yeah, yeah,
everybody
yeah.
gets all sad because they basically said, "Oh shit, we can't lose him. He's
Yeah,
like supposed to be king and shit." The I don't want Paizo to go down.
I gotcha. Yeah.
Paizo's too important.
Yeah, they're doing a lot right now. 1,500 people signed the orc from what I saw
Yeah,
today.
I did. So the Paizo, and we're working with the folks at Azora Law a little bit on that too. So directly involved there. But the what we need is somebody who has nothing to lose and a great case. We need to shop if we do want to sue. And I think that would be the key.
I saw somebody else say, where was it?
Oh, somebody did say there was an unnamed party in Linda Codega's article that was willing to go to court, but that wasn't Paizo. That is correct. I know who that party is. They would be a great option. So
I did see. Let me get your opinion on this, and again, it'll be purely conjecture because there's no way to know. But if it was revocable, rather, why didn't when they were doing the GSL for fourth edition? What, in your opinion, why didn't they try to revoke it then?
different people.
Okay. I figured, and this is something maybe you can clear this up for me because I think it's pretty easy question. Some people I saw in a comment, which is again just the internet person saying a comment on a video, which take that with a grain of salt, is that like the concept, the way revocable and irrevocable is written into contract law wasn't like a commonplace thing 23 years ago.
Yeah, so contracts have dramatically changed in the last 23 years. For example, I was just going through with a client. I represent a few game developers, well, quite a few game developers actually, but for digital gaming.
Mhm.
And they went through and they were trying to figure out what games they had licenses to because they wanted to release like a nostalgia edition. You know what I mean?
Yeah.
And so they handed me a bunch of contracts that were 2 pages long with mini clip and Newgrounds from 15 years ago.
Wow.
And that was the standard at the time, was the 2-page simple knock them out contract. And we've come a long way. Now those contracts are 40 pages because over time we have, one, developed as an industry,
Mhm.
and two, we have become incredibly litigious. We love to sue people, and so we find every single outcome.
Ah, see, that's kind of what I thought, and I'm glad to hear that kind of that tracks. Now, I do want to talk at least one other thing. In the statement, it says that it would not include royalty payment, financial reporting. Nowhere in the draft document does it state any of that.
No, it doesn't. It doesn't say that anywhere. It doesn't say it's royalty free. It doesn't say there's no financial reporting. None of it. And if you remember that four corners clause, remember
Yeah.
that is the problem. Is we can't have that four corners clause and not have a royalty free, no financial reporting section in there. That has to be in there.
Yeah. In the time we were sitting here too, I went back and looked in the SRD because this is something I'd seen being thrown around, and this may be something that needs to be dove into further. It's funny enough that the pages 56 to 104 ends right before the spell lists for the spellcasting classes.
Oh, really? That's great.
105 is the first spell list. So the concept that a lot of people have been throwing around, and this may be not something you can answer at this point,
Sure.
but can I reference the name Magic Missile without actually putting the context of what Magic Missile is in my non-OGL 1.2 thing under Creative Commons, just using the name of the spell? Like if I wanted to make, again, my own spellcasting class that's level 1 to 20, and I want to list the spell list, but I say, okay, it has Fireball, it has Chill Touch, whatever. I don't replicate what that is. I just use the name. Then, therefore, you'd have to go use the Wizard's official book to find what that is. I feel like that's not the case, but I'm curious what your thoughts are.
Do you want what I tell everybody, or what I would love to find out in court?
Can I get both?
Yeah, sure.
All right.
Playing it safe. You can't use that.
Got it.
What I would love to find out in court is whether or not somebody thinks that you can reference it without actually describing it or anything like that.
Yeah, did you see
Because
there was was the EFF article? Did you see that one a while ago?
Oh yeah, dude, you can't see it on my screen, but I got an EFF poster over there. I've worked with those guys a ton. I love those guys.
Yeah, they had said there was that one article they were describing invisibility specifically, and they said that like the invisibility, the even using things like action, it takes a minute to cast, and it's very generic terminology, like you wave your hand and then you become invisible. Whereas if it was like Noah's invisibility, and then it would be like you utter these specific words, and then all of these legal contract documents appear around you, and then you turn invisible, and things like that. Like it's a very specific definition of the way that spell works. That is like copyrightable. That is something you would need like the license to use. Whereas just saying like you wave your hand, you turn invisible until you attack or cast another spell is not. Which I assume, because there's a term, it's like nominal use or something.
Yeah, nominal use used to identify something rather than to describe it or to actually use it. You know what I mean?
Yeah.
So I think that there is something there.
Okay.
I wouldn't necessarily advise a client of mine that doesn't have fistfuls of money to argue that because I think that, like, hey, let's call it the beholder. Wizards is going to have fun suing you because they do enforce the beholder. So
that one I know very specifically. I see other people in the chat are saying things like, why not just call it missile instead of magic missile?
Or missile magic.
Yeah, I mean, and then cause we had the conversation like fireball is pretty iconic, but if I call it pyroblast and it does the same, roughly almost the exact same definition, but I call it something different.
Yeah.
Can I get around with that? Paralyzed person instead of hold person, things like that, I don't know if that's derivative too, though. That's the kind we were talking about too, right?
I think that there's ways around it. Here's the problem though, is as you're getting into that nitty gritty, you've got to get into that nitty gritty with every single one of them.
Yeah, which is a
lot. It's a lot. And so, I mean, short of you being DM Dave and just DM, by the way, DM Dave's written like 3 SRDs in a week.
Oh my God, the dude is, I can't keep track. Every day he's switching systems, he's changing names, he's doing everything.
He is an encyclopedia.
Yeah.
Like, shout out to DM Dave, like, and Griffin Saddlebag and all the stuff that they're doing to make sure that they stay compliant. Like, great people. But yeah, so I think that swapping around is not fantastic.
Yeah. Yeah, is there anything else? Because I know you want to jump off here. So is there anything else that you all right, this guy said it a couple of times. Says 5A can be changed to require registration and or financial report.
Let me look at 5A.
Which again, technically, I'll remind everybody, anything can change because this is a draft document. For the first time ever, a real draft. With no contracts or NDAs associated with it. So this actually is a draft, unlike the previous non-drafts.
5A can be changed to require.
I feel like anything
for the attribution provisions. Well,
Yeah.
no, it cannot.
I didn't think so. But again, nowhere in here does it state that there isn't a royalty clause or there isn't.
Right now, that exactly. So you know, I think it is. I think that person is right to be wary of it, but that's not where to go.
No.
So yeah.
All right. Well, I appreciate you coming and hanging out a little bit longer than we had originally planned to get through this.
Of course, it's my pleasure. You know, I always enjoy talking to you. If you don't mind me shouting out the tweet
by
that
all
I've
means.
got,
Shout out all your stuff. Do it.
I don't want to drop links in your chat, so if you don't mind dropping,
just
okay,
drop
cool. I just want to make sure I don't get killed here.
I don't think you will, but if you do, I'll
all right.
drop it myself.
If I get nuke-abated, 1 second. I did post a lot of the thoughts that we talked about today here on the Twitter, and which is, you know, my lawyer friend. So feel free to go and like that. Oh, that doesn't really give you a link, but there you go. Feel free to go like that, follow that, read that. If you have any more questions, spread that across the internet, because here's what we need: is we need a coordinated and focused response to this. They're going to be soliciting feedback. This is our best opportunity to give it to them. And so a coordinated community response that is focused on the key here is going to be give us our best chance of success. They're not going to walk back revoking OGL 1.0A. Somebody will fight them, but in the meantime, let's stick with the guns that we're given, and go out there. Remember, royalty free, irrevocable, and keep on opening D&D.
Yeah, well, thank you so much, folks. Feel free to continue. I'm gonna hang out here for a little bit. Noah's gonna jump off. More to come on this, and then again, also more to come on all the other licenses and things that have been going on. So I think you know, in the long run, people are still gonna go back to D&D. Some people are. Some people probably already have. Some people never left, if we're being honest, and that's okay. You shouldn't shame people, especially people that are just getting started or just starting to play, or they're financially invested so much into D&D that it's not just easy for them to say, screw this, I'm going to go play something else. It's the same concept of not harassing Wizards of the Coast employees, right? Don't harass people that still want to play D&D. We made our point. We have to keep continuing to stick to this to make sure we get what we want, or at least as much as we can. Again, we know 1.0A is going to be revoked. I'm pretty sure there's no question of that. But it's what else we can get before we get there. Again, be sure to go follow Noah on Twitter for sure.
Yeah.
I just put the Medium link in the chat there in case his didn't go through. But and I'll also, for those of you who are watching after the fact on YouTube, there'll be links to all that in the video description as well. So
all right, buddy. Well, I'll leave you to your stream, by the way. Oh, dang, it just went past what I was going to say. We started streaming 69 minutes ago. Nice. And good luck, Godspeed. May the force be with you always.
Thank you.
Bye.
Bye.